What if I told you that the most liberal and the most conservative justices on the Supreme Court just looked at each other across that marble bench and agreed? No, not on some small procedural technicality, not on a scheduling matter, on gun rights. That's right, Sotomayor, Ketanji Brown Jackson, two of the most progressive jurists in the country, sided with Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett, and Chief Justice John Roberts. 7-2, 7-2. And what they decided is already changing the rules for millions of gun owners across America. And there's another case still cooking that could flip gun rights in your state upside down. Whether you're a Second Amendment diehard, a gun control advocate, or just someone who wants to understand what the highest court in the land is actually doing to your rights, you need to watch this entire video because we're going to break this down in plain English. No legalese, no spin, just the facts, the history, the implications, and what it all means for you. Setting the stage, the legal landscape. To understand what just happened, we need a quick history lesson. Don't worry, I'll make it fast and I'll make it matter. For most of American history, the Second Amendment was basically a legal ghost. Courts rarely enforced it. Gun laws were passed, challenged, and the courts mostly shrugged. Then came 2008, District of Columbia v. Heller. The Supreme Court ruled for the first time in history that the Second Amendment protects an individual right to possess a firearm for self-defense. Not just militias, individual citizens, you, me, your neighbor down the street. That was a massive shift, but it left a lot of questions unanswered. Like, okay, you have the right, but how far does that right go? What can the government still regulate? Fast forward to 2022, New York State Rifle and Pistol Association v. Bruen. And this is where things got really interesting. The court didn't just reaffirm Heller. It basically threw out the old way courts were analyzing gun laws and replaced it with something entirely new. Under the old framework, courts would weigh the government's interest in public safety against how much a law burdened gun rights. It was a balancing test. The Bruen court said, throw that out. Now the test is, and this is crucial, is the gun law rooted in the text, history, and tradition of the Second Amendment. If a similar law didn't exist in 1791, when the Bill of Rights was ratified, or roughly around the founding era, it better have a very close historical analog or it's unconstitutional. This one decision sent shockwaves through every single gun law on the books in America. Federal courts started striking down restrictions left and right. Gun owners started winning cases they never would have won before, and state legislatures scrambled to figure out what they could even legally do anymore. That's the battlefield we're on right now. And two massive cases have been fought on that battlefield, one already decided, one still pending, a ruling that could drop literally any day now. Let's start with the one that already happened, because it might not be what you expect. Case 1, Bondi v. Vanderstock, the ghost gun ruling. The year is 2022. Technology has changed everything. You can 3D print just about anything, and that includes the parts to build a functioning firearm at home, with no serial number, no background check, and no paper trail. These are what people call ghost guns. Now let's be clear about something. Ghost guns aren't just a theoretical concern. Law enforcement agencies across the country, from Chicago to Los Angeles to New York, were reporting a massive spike in ghost guns recovered at crime scenes, untraceable, no serial numbers, no way to figure out where they came from or who bought them. So in 2022, the Biden administration's ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, issued a new rule. The rule said, if you're selling a kit that someone can assemble into a functioning firearm in under an hour, that kit is a firearm under the Gun Control Act of 1968, which means it needs a serial number and the buyer needs a background check. It seems pretty logical, right? Not to Jennifer Vanderstoke and a coalition of gun rights advocates. They sued, they argued the ATF was overstepping that the Gun Control Act of 1968 only covers finished firearms, not parts kits. And a federal judge in Texas agreed with them, blocking the rule. The case worked its way up. And eventually, it landed at the Supreme Court of the United States, Bondi v. Vanderstoke. And here's where the story gets fascinating. On March 26, 2025, the Supreme Court ruled 7-2 to uphold the ATF's ghost gun rule. Who wrote the majority opinion? Neil Gorsuch, Donald Trump's first Supreme Court pick, the guy gun rights advocates celebrated when he was confirmed. He wrote the opinion upholding the gun regulation. And who joined him? Not just the conservative wing. Joining Gorsuch were Chief Justice Roberts, Sonia Sotomayor, Elena Kagan, Brett Kavanaugh, Amy Coney Barrett, and Ketanji Brown Jackson. 7 justices, liberal and conservative, agreeing. Only Thomas and Alito dissented, and they dissented for different reasons, which is itself kind of remarkable. So what did the court actually say? Gorsuch used an analogy that I think is pretty genius. Imagine you order a table from IKEA. It comes in a flat box, 100 pieces of wood, screws, and instructions. Now, is it a table? Your friend might say, I just bought a new table. Not, I bought some flat-packed wood. Because the obvious purpose, the obvious function is that it is a table. The same logic applies to a ghost gun kit. You order it. Inside the box, all the pieces, all the components, assembly instructions, a half hour of work later, you have a gun. The court said, that kit is a firearm for the purposes of federal law. The ATF had the authority to regulate it, and the rule stands. Now, what does this mean for you? If you're a gun owner who's frustrated by ghost gun regulations, this ruling is a loss. The ATF's 2022 rule survives. Background checks and serialization requirements on these kits are here to stay, at least for now. But here's the important nuance. The court was very careful about how it framed this. It was a facial challenge, meaning Vanderstok's team argued the ATF rule was invalid across the board. For every single situation, the court said no. We can't throw the whole rule out just because there might be some edge cases where it doesn't fit. At least some of the kits the ATF is regulating clearly qualify as firearms. That leaves the door open for future as-applied challenges. Cases where someone argues this specific kit in this specific situation doesn't meet the standard. Those battles are still coming. But make no mistake, this was a landmark ruling. The federal government can regulate ghost guns, and it took a 7-2 supermajority crossing every ideological line on the court to say so. Why did liberal justices side with this outcome? Public safety. The proliferation of untraceable weapons in crime was something even the most gun-friendly justices couldn't ignore, evidenced by the breadth of the coalition. Why did conservative justices sign on? Because this wasn't really a Second Amendment case. It was a statutory interpretation case. Does the Gun Control Act of 1968 cover these products? Gorsuch said yes, reading the law as written. It wasn't about whether ghost guns can be banned under the Constitution. It was about whether Congress already banned them in 1968 without knowing it. That's a subtle but important distinction, and it's why this case, while massive, is just the opening act. Because the next case, that one's pure Second Amendment, and it could change your daily life. Case 2, Wolford v. Lopez, the case still being decided. Maui, Hawaii, paradise on earth. Jason and Allison Wolford are licensed, legal concealed carry permit holders. They went through the background checks. They did the training. They followed the law. They got their permits. And then they got arrested. Why? Because they walked into a business, a private business open to the public, without asking the owner's permission to carry their legally permitted firearms first. Hawaii passed a law in 2023, Act 52, that said if you have a concealed carry permit, you cannot bring your gun onto private property that's open to the public unless the property owner has given you express permission first. Think about what that means practically. Every time you want to enter a grocery store, a restaurant, a shopping mall, a gas station, you would need to first find out whether the owner has said guns are okay. And the default is guns are not okay unless stated otherwise. The Wolfords, along with the Hawaii Firearms Coalition, sued. They said this violates the Second Amendment under the Bruen framework. There's no historical tradition of requiring armed citizens to get permission slips before entering private businesses. The Ninth Circuit disagreed. It upheld Hawaii's law. But this is where it gets spicy. The Second Circuit, covering the East Coast, struck down a similar law in New York. You got a circuit split. The same constitutional question, 2 different answers from 2 different federal appeals. Courts, that's exactly the kind of conflict that brings the Supreme Court in to settle things once and for all. SCOTUS took the case. Oral arguments happen January 20th, 2026, and the decision is expected any day, likely by the end of June 2026. Now, we can't tell you how the court will rule. The decision isn't out yet, but we can tell you what happened during oral arguments because it was revealing. Here's what we know. Chief Justice John Roberts, not known for fiery rhetoric, openly suggested that the Second Amendment has been treated as a disfavored right by lower courts. That's a significant shot across the bow. Justice Samuel Alito told Hawaii's lawyer point blank that the state was relegating the Second Amendment to second-class status. Justice Gorsuch and Justice Kavanaugh were both deeply skeptical of Hawaii's position. And here's the kicker. Hawaii's law also has a vampire rule. I am not making this up. It's called that because of the Dracula folklore. A vampire cannot enter your home unless you invite them in. Hawaii's law works the same way. A gun cannot enter a private business unless the owner invites it in. The justices grilled Hawaii's lawyers on whether this had any basis in American constitutional history. Spoiler alert, it didn't seem to go well for Hawaii. The observable reality from oral arguments is that the conservative majority, all 6 Republican appointees, appeared deeply skeptical of Hawaii's law. But here's the thing that makes this more complicated and more interesting. It's not just about Hawaii. California passed a nearly identical law, SB 2, at the same time. These 2 cases were consolidated in the Ninth Circuit. A ruling in Wolford v. Lopez affects both states simultaneously, and the implications go national. If the Supreme Court strikes down Hawaii's law, it would effectively establish a constitutional presumption that licensed concealed carry holders can bring their firearms into private businesses open to the public unless the owner explicitly posts a prohibition. Think about what that means. Walmart, Starbucks, your local restaurant, your gym, the default flips. If you're a gun rights advocate, this is huge. No more guessing games, no more am I allowed in here. Your constitutional right follows you through the door. If you're on the other side of this debate, this is alarming. You believe businesses and states should have the power to set these defaults. A ruling for the gun owners would take that power away from 50 state legislatures and hand it to permit holders. And this isn't theoretical anymore. This decision is coming soon. Let's zoom out and talk about the bigger picture. The bigger picture, what this means for America. Here's something worth sitting with for a moment. In the span of just a few months, the Supreme Court has been asked to answer questions that go to the very core of what the Second Amendment means in modern America. Does it cover weapons that didn't exist in 1791? Ghost guns, 3D printed firearms, assault-style weapons? Where does text, history, and tradition even begin to apply when the technology is completely unrecognizable from the founding era? Does the right to bear arms follow you into a shopping mall, into a bar, into a children's playground, or does the right stop at the door? These aren't abstract philosophical questions. They affect real people every single day. And what's remarkable, and what your media probably isn't telling you enough, is that these cases are producing unexpected coalitions. In Vanderstoke, you had Gorsuch writing an opinion that gun control advocates could celebrate, joined by the court's liberal wing, not because ideology collapsed, but because the legal question, when stripped of politics, pointed in that direction. In Wolford, you have justices across the spectrum wrestling with a genuinely hard question: who gets to set the default? The state, the property owner, the gun owner. These are not simple questions. And frankly, anyone who tells you they're simple is selling you something. What's also worth noting, there's a massive pipeline of gun cases working their way up to the Supreme Court right now. Cases about magazine capacity limits, or large capacity magazines, even arms, under the Second Amendment. Cases about the federal ban on felons possessing firearms, which has been challenged dozens of times in lower courts. Cases about carrying in sensitive places like parks, beaches, hospitals. The post-Bruen era is producing a complete restructuring of American gun law, case by case, inch by inch. And the court we have right now, with its 6 Republican appointees and 3 Democratic appointees, is going to be making these calls for potentially decades. The 2 youngest justices on the current court are both in their 50s. We're not talking about a temporary snapshot. We're talking about the shaping of constitutional law for a generation. What you need to do right now. All right, so what does all this mean for you, practically speaking, right now? If you're a gun owner, number 1, know your state's laws. After Bruen, after Vanderstoke, after whatever comes down in Wolford, the patchwork of gun laws across states is more complicated than ever. What's legal in Texas is not legal in California. Know the rules where you live. Number 2, if you carry a ghost gun or own a parts kit, understand that federal serialization and background check requirements now apply. The Vanderstoke ruling upheld those rules. Compliance isn't optional. Number 3, if you're a concealed carry permit holder, watch the Wolford v. Lopez decision very closely. It will directly affect where you can carry in public-facing businesses, especially if you live in a blue state. If you're concerned about gun safety, the Vanderstoke ruling was a significant win for regulation. The ATF's ghost gun rule survives. Background checks and serialization now apply to these kits. That's a meaningful check on untraceable firearms. But understand the Bruen framework has fundamentally shifted the terrain. Gun laws are now being tested against a historical standard that was set in 1791. That is a very different world than the world we live in today, and courts are going to be wrestling with that mismatch for years. For everyone, pay attention to these cases, read about them, talk about them, because the Supreme Court is making decisions that affect your daily life. Where you can go, what you can own, what the government can regulate. These aren't just legal footnotes. These are the rules of American life being rewritten in real time. The bottom line, the Supreme Court just proved something that everyone in Washington seems to have forgotten. The law is bigger than politics. 7 justices, liberal and conservative, looked at ghost guns and said, yes, Congress already covered this. The law is the law. And now they're about to tell us whether the Second Amendment means you can walk into a Walmart in Hawaii with your legally permitted firearm without asking anyone's permission. And that decision is coming. We will cover it the moment it drops. If this video gave you clarity, hit that like button. It genuinely helps this channel reach more people who want real analysis, not partisan noise. Subscribe and hit the bell because when the Wolford ruling comes down, you're going to want to know about it immediately. We will break it down for you, just like we did today. Drop a comment. I want to know, do you think the Supreme Court got it right on ghost guns? And how do you think they should rule on Wolford v. Lopez? The conversation in the comments is always fire.